Okay. Good morning.
Good morning. How are you doing?
Good. It's Roger Rotnam.
Roger Rodham. Yep, that's right.
Rotnam. Okay. Okay, Mr. Roger Rotnam. I don't know if you can see Mr. Farmer off on the from the camera here.
Yes, I can.
Okay. Are you an attorney?
I am.
Okay. Mr. Farmer, if you please raise your right hand. You swear the testimony about to give shall be the truth, whole truth, and nothing but the truth. So help you God.
I do.
Okay. Let me just bring the case up. This is on a discovery, correct?
That's correct.
Okay. What I'm going to do is I'm going to print the okay, so since I last looked at this, Mr. Roger Rotman, you provided a response.
Yes, Your Honor. That's right.
Okay. I just make this go a little smoother. I'm going to print them. Oh, my printer's out. Now let's see what I can do. Let me see if it will. Printer this morning.
I can give it to you.
Okay, I'm going to try it one time, Ben, and if I don't, I'll let you know.
Okay.
I have a copy for you.
No, it's printing for some reason. It likes this case.
Okay, thanks. It.
Okay, one second. Let me just print these documents. And then you have a motion for discovery. Print this. Okay, I'm going to have on the screen your petition, okay? Okay, I have on the petition, your petition on the screen, and I have your motion, and I have Mr. Rothman's response. Okay, so Mr. Farmer, it's your motion. Go ahead and tell me what you're asking for and why.
Your Honor, just real quick, there was an amended petition filed, so I think this is the original petition, but Mr. Farmer filed an amended one.
Okay, let me get that one second. Thank you.
There was a little bit of a mix-up on the petition. The court had my original petition.
You're gonna speak a little louder, just so Mr. Roger
There
Rothman.
was a little bit of a mix-up on the petition.
Okay,
The court had my original petition that had the correct information on it, but when PayPal sent me the response, I noticed that the petition was not the one that the court had. So I came down here and got that straightened out. The court resent the correct petition to the defendant.
okay,
But the one I originally submitted, which is stamped by the court, was the correct one that I had.
Okay, well, I don't know if it's gonna make a difference, but go ahead.
Good morning, Your Honor. I want to apologize in advance if I seem a little nervous because I don't have a chance to stand in front of the judge very often. So
Quite all right.
first off, I want to thank the court for allowing me an opportunity to present my arguments on each one of my discovery requests. and why the court should grant each one of them. If the court please, I'd like to start by giving a quick synopsis of my underlying case.
Okay,
On June the 25th of this year, I ordered a product from a website called AuthenticSite.com and paid for it through PayPal. I never received the product and then contacted PayPal for a refund. After the merchant provided a tracking number, I informed PayPal that the tracking number was not for my package and that it was not delivered to me. They still denied the claim. While in the process of researching the tracking number, I learned that PayPal was not following up with the carrier. In this case, it was UPS, and was instead simply taking the word of the merchant that the package had been delivered and then denying the claim. It would have been very easy for PayPal to verify the tracking information if they really wanted to. These, I transmitted these to the defendant, and I just wanted to give you an example of what I'm talking about tracking numbers.
Mr. Roger Rothman, did you receive these exhibits? Do you know?
Yes, Mr. Farmer sent me those yesterday, so.
Okay, go ahead.
Okay, so Exhibit A is a picture or a photograph, screenshot of a tracking number that a common citizen, anybody, can go on the website and type in a tracking number and get information. And you see here, this one here, this is a FedEx tracking number, but the same thing goes for UPS. You see the exact same thing. So you see on the page here that you can see that it was delivered, and it's tells you who it's from, El Paso, Texas, and where it was going to, Eagle River, Alaska. If you click on travel history, all you do is get some information about when the driver picked it up and so forth. That's what a person would see if they had no business with this tracking number. That's all they could see. Exhibit B is the same exact tracking number if you were to log in and look at the tracking number. And so anybody that creates a tracking number can see the detailed information, which this company, the company that sent me the product, would have been able to produce this document and show PayPal that who it was sent to and when it was received. So you see at the top right-hand corner, I logged in to the account, my account, and there at the bottom, you then see who it was from, the details, and who it went to, and the address that it was delivered to, and so forth. And then it was delivered. So you get a lot more information if you own the tracking number than you would if you just tried to look it up. What PayPal is doing is accepting.
What do you mean when you own the tracking number? If you're the sender?
Yeah, if you're the person that sent the tracking number or the one receiving it,
Okay,
you can see the detailed information. What PayPal is doing is accepting a watered down version of tracking numbers from their vendors and not doing any due diligence on figuring out that this is who it went to. And this is exactly what happened in my case. The merchant picked up a bogus tracking number from UPS and sent it to PayPal, and all it said on there was it was delivered to somebody in El Paso, Texas. And they never did anything after that to try to verify that in fact the tracking number was bogus. So my discovery request goes to the heart of proving my underlying case that PayPal is involved in systematic cheating their customers and conducting business in a fraudulent manner. I have also been in touch with Ken Paxton and the Office of Consumer Protection, so this material will also be helpful in their investigation. I would like to now address each one of my discovery items.
Okay,
You mind if I get a drink of water?
no, go right ahead.
Headphones. Okay. Number one, Hong Kong Capri Company is the company that PayPal sent my money to. So I'm only specifically asking for information or contact that PayPal has had with Hong Kong Capri Company, nobody else. And there shouldn't be too much information that PayPal had of it, but this company was only in existence for a few months. They're currently nowhere to be found. Their website has been shut down, and they were only in business long enough to cheat people out of as much money as they could. So this is specifically just about PayPal's communications that they may have had with this particular company that they were doing business with. I'm sure there's a merchant ID or something that they can use to track these. And by the way, these discovery requests are only for digital information. I don't expect the defendant to have to print up a whole bunch of pages. They can simply put it on disk and provide it to me in that manner. Number two is information on the site AuthenticSite.com. This is the website that the Hong Kong Capri Company used to sell their products on. So if there's anything that PayPal has regarding communications that has anything to do with AuthenticSite.com, I'd like to see those there. Number three is simply a record, any record they might have on my case. I've listed my case ID that PayPal can use to search through the records or any communications they have regarding my case. I did a lot of talking to them through a chat session, so I don't have all that information. I need to get that from them on my communications I had with them. Number four is communications between defendant and PayPal subscribers that have to do with Hong Kong Capri Company. This will give me an idea of how PayPal has handled any complaints or anything having to do with the company that was cheating people out of their money. And number five is just a sister request for that same thing. Anything between their customers and them mentioning AuthenticSite.com. Oh gosh.
You all right?
Yeah, I'm all right. It's just my throat and I talk a lot. My throat starts to be itchy. Okay. The last one is just anything that they have in their files having to do with discussion regarding this lawsuit, the subject matter of this lawsuit, or myself, frankly. So that's pretty much the summary of my requests that I have for them producing records for me so I can better prepare my case for the trial.
Okay. Mr. Roger Rock?
I'd like to respond just quickly to a couple of things that defendants wrote in their response. Number 3, PayPal is relying on a contractual agreement between them and me to attempt to limit their liability. Once PayPal misrepresented itself, the contract becomes null and void. At trial, I will show that they did that very thing. Number 5, according to the Texas Rule of Civil Procedure, Section 500.9, it states that the discovery request must not be served on the responding party unless the judge issues a signed order approving the request. Is that still the case, Your Honor, or I should not?
Discovery needs to be approved
Okay.
in justice court.
That's why I was curious as to why the court sent the defendant copies of the my motion before you had ruled on or done anything. So
Technically, you should have sent it when you filed it to him. Anything you present to the court, you should present to the other side.
okay, well, that's why I was confused. It said the discovery request must not be served on the responding party.
That means you can't initiate discovery on your own. You have to go to the court, and the court hears the motion, and then they decide whether you can do the discovery.
Oh, so what this means, I could have sent them copies of what I was asking for, but not, it wouldn't have been a service.
It wouldn't have been effective until the court said you have to answer those.
Okay, so in the future, if there are more discovery requests I need, I can send them copies beforehand.
What you do is
Notify them.
you're making a motion to the court. Judge, can I do this discovery? And then you send a copy to the other side. And so that's if the judge decides on his own that you can do it, he'll approve it. Otherwise, if he has some kind of question about it, you might set it up for a hearing, which is exactly what we did today.
Okay. Well, that clarifies that. And number 8, my discovery request is only for digital files and not for paper copies. There should be very little expense associated with this type of request. So I don't see that the burden upon PayPal to do these limited requests. In summary, I hope the court grants my request and finds in my favor.
Okay, Mr. Ryder Rotnam, your response?
Yes, Your Honor, thank you. I want to start by saying, Mr. Farmer, being in front of a judge, the nerves never go away. And I think one of my law professors told me that if you don't have nerves when you're in court, then you're doing something wrong. So believe me, it's completely normal. But yes, Your Honor, Mr. Farmer did a good job of giving you some background about this case. Really what this comes down to is a transaction in the amount of $99.49. It was a $100 transaction to a company that Mr. Farmer alleges was a fraudulent or a scam company. And Your Honor, I guess the holdup here is Mr. Farmer is also tacking on $19,000 in punitive damages, which PayPal does not believe there's any basis for. There's not an allegation of fraud or, malice or gross negligence on the part of PayPal in this case. And as Your Honor knows, under the Texas Civil Practice and Remedies Code, punitive damages, exemplary damages are not to be awarded just based on ordinary negligence or even bad faith. And plaintiff has to prove that by a clear and convincing evidence. And I don't want to get into, what plaintiff may or may not be able to prove in this case, but it's pretty clear with the terms of PayPal's user agreement that PayPal would not be liable for anything other than the actual amount of direct damages in this case, which is the amount of the transaction at issue, and that's $100. We don't believe that discovery would be reasonable or necessary for a $100 case. And we don't think that, going through the burden, the expense, both on the attorney side and on PayPal side of searching for documents and kind of going through the motions of producing discovery, responding to discovery requests would be proportional to the amount in controversy where there's only $100 at stake. I will say though, just to fast track this and kind of if we can come to an agreement. I do think that the first few requests that Mr. Farmer is seeking to propound on PayPal, those may be relevant to his case. I think what's relevant here, Your Honor, is the transaction details between Mr. Farmer and this company, as far as, you know, just the details of that transaction, as well as Mr. Farmer mentioned there were some chat logs between him and PayPal's customer service. I think those items would be relatively easy for PayPal to find and to search for, to produce, if they exist, as well as communications with the company, if those exist, if there's any chat logs. I do want to kind of zero in on the other requests, number 4 and 5. I think Mr. Farmer is asking PayPal to do a search of any PayPal customer where there's even a mention of these companies' names. I think going through that kind of exhaustive search of PayPal's entire system would be burdensome, would not be relevant to this case, which involves a $100 transaction between Mr. Farmer and this company. But I do think to alleviate whatever concerns Mr. Farmer may have about this company, if there are limitations or restrictions that were placed on this company's account from PayPal, there would be some documents that evidence that, whether it's an email to the company, you know, something talking about a limitation that was placed, and that may be due to a customer like Mr. Farmer complaining that an item was not actually received. And so if PayPal did an investigation like that, if there were disputes that were filed against this company, there would be evidence of that, and that would be something that we'd be happy to search for and to produce. But as worded, at least request number 4, 5, and even 6, we just think those are broad. Those would be burdensome. Those wouldn't be proportional to the needs of this case, which is determining the details of this $100 transaction and whether or not this company was actually a fraudulent or scam company. And so we would ask Your Honor to deny at least the second half of these discovery requests. And if Your Honor is going to grant any form of discovery in this case, we would just ask to limit it to kind of what we talked about, maybe chat logs between the plaintiff and PayPal, chat logs between PayPal and this company, and then any kind of transaction details about the transaction at issue. We don't believe that any other discovery requests and asking PayPal to kind of do this exhaustive search are going to be reasonable or necessary for this case, which again, we believe comes down to a $100 transaction. And so, yeah, Your Honor, we would ask that you deny the motion, but PayPal would be okay with that very limited scope of discovery.
Okay, I'm of the opinion of 1, 2, and 3, I think are sufficiently relevant that they can be granted. 4 and 5, I do have a problem with, because if they had proving somebody else's case doesn't prove your case, so you're asking for other instances in these other 4 and 5. But like Mr. Rotnam said, how do we, I'm going to grant 1, 2, and 3, but I would like to alter or modify one of these other ones to, you said if you had any investigation, is that what, if this company had been investigated, authentic.com, is that what you're referring to?
If the company had, if there was an investigation that PayPal conducted or some kind of dispute against this company, then we would probably have, there may be a limitation or restriction that was placed on the account.
Okay.
And if there's evidence of that, we can look for that.
Okay, so I'm going to grant 1, 2, and 3. And then in addition to that, 4, any investigation or restriction limitation placed on authentic.com by PayPal. Mr. Farmer, do you have any problem with that?
Not at all. I was just, the request of trying to go to a pattern, even though it might be other people in the company, other customers that have had the same case. I was trying to establish a pattern that PayPal might be engaged in.
Yeah, well,
this, but I'm satisfied with the ruling.
Investigation, records pertaining or related to an investigation of or limitation or restriction on, is it authentic.com?
AuthenticSite.com.
Oh,
And there's a dash between authentic and the word site. There's a dash in between those two. Well, that's relevant to their search.
so 4 and 5 are granted. Let's talk about 6. All documents, notes, written communications, electronic information, ESI, and tangible things, documents, evidence, or concern any communication between you and any other person. Yeah, I think that's too broad. I'm not gonna grant 6. So it's just gonna be the 1, 2, and 3, and then I just unwrote the 4 that's granted. And we will email this to you, and then Mr. Farmo, you'll walk out with a copy.
Okay.
So I wrote it on I didn't wrote it on your order, so I'm gonna have to rewrite it. But I'll rewrite it and we'll email a copy to you, Mr. Roger Rotman, not Rotnam. Let me keep you that. I think it's MAM, it's NAM. I'm sorry.
Oh, no worries. Thank you, Your Honor.
And we have your email?
Judge, I do have all their emails,
Okay,
and yeah, if they want to set up a bench trial date right now, we can do it, Judge. I have a date in mind.
great. Okay, you all ready?
I have November 30th, 2021 at 10:45 a.m.
November the 30th. Okay, I don't think I have anything going on that time.
Yeah, I should be available as well.
Mr. Farmer, you had a, okay, so we have sufficient time. You'd have 30 days to produce this stuff. That would take you to about November 20th, and then the trial would be.
So what would be the procedure of when I receive their discovery stuff that they're sending to me? It opens up more stuff that I might want to see. So I just contact them and ask them for it before trial?
Well, your discovery is limited to what's been granted today. I mean, you just can't orally say, hey, I want this now.
So there's not a procedure for a second round of discovery then, depending on what.
Well, there could be if there's good cause for it. You know,
Okay.
they have to show good cause.
Okay,
You know, this is a small claims court, and probably limit discovery and have it go through the judge. We're just not going to have, on and on discovery going on and on.
okay,
But if it's relevant and you have good cause to request something, then I would entertain it. I'm not saying I'm going to grant it, but I would entertain the motion.
okay.
But I think what we've covered, sir, today, certainly, I think would be sufficient unless there's something that I just don't know of or none of us know of. But I think it should be sufficient.
Well, that's all I'm asking is if something comes up that is relevant, and I think it's relevant, I'd like to present to you to see if you think it's relevant, but more than likely there probably won't be anything.
Okay. So Roger Rotnam, can we shorten the period to respond? Would that be acceptable to you? Just November 30th date?
Sorry, you cut off a little bit. Can we shorten?
Can we
the-
short, can your response, can we go 21 days for get your responsive documents just to allow sufficient time between the response date and the November 30th date?
Yes, I think that'd be fine.
Okay. So I'm going to order that they get you the responsive documents within 21 days of today. Is that all right?
Yes.
Okay.
So 21 days from today would be for the,
November 10th, somewhere around there.
and that would give me around 10 days, 10 days to go over the information, around 10 days.
The date of trial? The date of trial is November 30th, so it'd be about 20 days or 19 days, somewhere in that area. Okay, you submitted an order too, and I don't have that order for some reason, didn't you?
Yes, it was right behind the,
I thought I had it right in my hand, and I don't know. I will get that, and we will email you a copy. Mr.
Okay,
Rod-
thank you.
Okay, thank you, sir.
Mr. Garza, what time did you say on November 30th again?
It'll be at 10:45 a.m. and it's Mountain Standard Time. It's El Paso time.
Okay, great. Thank you.
Mr. Rotnam, where are you at?
Well, I'm in Central Time. I'm in Austin.
Okay, yeah, so you're an hour ahead. Okay. Thank you, sir.
Okay, thank you, Your Honor.
I'm just gonna get your order, 1 second.
I have a copy if you-
Okay, you do- what do you do?
I have a copy there. Yeah, all I have is the-
I think, I don't make it, I think you included on your motion.
Yeah, I did.
I don't think there was ever an order filed with it, Judge.
Okay, I'm just gonna make this in order.
Yeah, it wasn't an order. It was just a motion with, that's all that was filed.
Okay, I'm just gonna use this as an order. This would be, uh, so if we go 21 days from today, it'll be November.
It would be the 11th, Judge. I believe 1, 2, 3,
Okay,
the 11th.
November 11th is that's first. Okay,
November 11th is the date they're due.
yes,
And the trial is on November the
30th.
30th, so that's
If,
19 days. Okay.
Ben, can we just give him some, well, no, I'll write it down on this paper.
No, I'll give him some, as he's walking out, I'll give him a new one, Judge. We're gonna use the same information,
Okay, great.
the same Zoom information. It'll be exactly the same. And as soon as you end this meeting, I'll go in there and I'll modify it.
Okay. Okay, thank you, Mr. Farmer.
Thank you.
If you step, you go through the lobby area, if you just go to one of those windows, you'll get your copy of the settings.
Thank you.